Regular meeting. So I'm calling the meeting to order. Roll call, please. Director Ricci.
Here.
Director Calandri.
Here.
Director Urasic.
Adrian Wright.
Right, thanks, Adrian. Director Urasic will be calling in shortly. Director Chisam.
Here.
Phyllis Stannon.
Good morning, I'm here.
Good morning, Phyllis. Adrian Well.
Yes.
Good morning, Adrian. And Craig Harton.
Here.
We also have present Matt Knudsen, Pete Thompson, and Angel Fitzpatrick. And Holly Hughes. Okay, we will adopt the agenda. Do I have a motion to adopt the agenda?
I move that we adopt it.
Second.
Okay, with a motion and a second. May I have a roll call vote, please? Director Ricci?
Yes.
Director Calandri?
Yes.
Director Reka?
Yes.
Director Chisam?
Yes.
And Director McLaren? Yes. Okay, with that, we will go to number 4, which is public comments for non-agenda items. This portion of the agenda allows an individual the opportunity to address the board on any item regarding WATERMASTER business that is not on the agenda. Do we have any public comments for non-agenda items?
Yes.
Go ahead, please.
Hi, this is Debbie Farrow, Secretary of Antelope Valley Mutual Water Company. And I would like the opportunity to address the board on an item that is not on the agenda today, which is the waiver of the late fees for Antelope Valley Mutual Water Company on our replacement water assessments for 2016 through 2019. The reason I am coming again on this particular item is that I would like the board to consider the fact that at the last meeting where it was on the agenda, it was not fully discussed and it moved on to the next agenda item. And I had spoken up about it, and so that went back to the previous item, which was the waiver of late fees. And they took a motion and a second and then a vote. And while it was motioned and seconded to deny the late charges, the waiving of the late charges, when the vote happened, it was not a unanimous vote. And so the motion did not pass. So I'm asking once again for the board to look at the waiver request from us on the basis of, I wanted to point out that it was mentioned by board members that they did not want to create a precedent of waiving late fees. And I wanted to point out that Antelope Valley Mutual Water Company should not be considered, that we should not be considered as our waiver being considered as a precedent-setting thing, but that it should be considered by itself as I believe probably each one should be, depending on the situation. Our situation being that we were, and I'll just put out the timeline quickly here, that we were presented with the bills for 2016 through 2019 in December of 2020. that was the first time that we saw the actual bills being charged to us for the amounts of money for those years. And we, in 2019, had been given the letter saying that we needed to submit a new production application, and all of that was required with that, and which we did during that year of 2019, and submitted during that year of 2020, because it was at the end of 2019. We did that during 2020 and did all of the requirements that were required then. Then we received the bill. Once we had that done, we received a bill for all of the replacement water assessments and the administrative assessments for 2016 through 19, which we paid then for the administrative assessments. We were told that it was possible for us to pursue a transfer. We began that in early 2021, doing exactly what they had told us, meaning the WATERMASTer. And so we were working on that. Then in August of 2021, we received a bill for the 2020 administrative and replacement water assessments. And on that bill appeared a delinquent charge, the 10% for 2016 through 2019 of almost $12,000. At that period of time, as I said, we were working on a transfer agreement through 2021, and we were in the process of getting that approved with the person that we got the transfer with, and we had not received any notice of delinquency, as I have found out that we should have received a notice of delinquency after the delinquent date of our 2016 through 19 assessments being due. As I said in previous meetings, we worked hard to try and get this transfer through. It took a lot of time, but had I known, or we known, that there was a delinquency still going to be owed, even though we were trying to satisfy the replacement water assessment through the transfer, that could have changed things in how we were doing things, because like I explained at a previous time, when you are working with someone to try and get to an agreement, it takes time. And when you're the one requesting something from them, you want to honor them and not push too hard. However, had I been aware that we were going to have to pay the late fee and the transfer, I definitely would have pushed harder to try and get that done sooner. We began that process in May of getting a transfer, and it finished in September. It took that long, and we got the delinquency charge in August. So we were in the midst of doing it, and so to get it done, I've just been asking the board, what could we have done differently? What if we'd have paid money towards the delinquency delinquency charge? Would we have received a refund? I don't think so. What could we have done differently? And the fact that we did get an approved transfer, that satisfies the replacement water assessments, but yet we are receiving a late charge on top of that now. And the reason that I don't think it should set a precedent is that you had brought up that there are other water companies, or not maybe water companies, but other people who owe money but have ignored, or you're reaching out to them about it for much longer than we did. Ever since we were notified that all of this was happening, we responded on every single item that we needed to do, the new production application, starting it off, and then when we got the bill, we started on the transfer, and we did, the meter and all of those things, just as we were asked to do. So I don't believe that it sets a precedent that if if someone you're dealing with does everything you ask them to do, and works towards that goal of what you want and satisfying the replacement water assessment, then I believe it should be considered. Perhaps the policy needs to be changed to where when someone first finds out about this, like we did, that they get told that there's going to be a late fee that you have to charge as well. That could have changed how much, it could have changed a lot of things in how we were looking at what we could do at the time. The fact that the transfer was not going to satisfy that late charge being charged too, that I think that needs to be addressed. The fact that we didn't receive a delinquency notice to where we could have responded, and like I said before, perhaps pushed harder to get that transfer completed, because like I said, we were in the process. Those are all things that I think should be taken into account, and the precedent should be doing the right thing, not doing the same thing just for the sake of doing the same thing for every single person, but doing the right thing. And sometimes it takes looking at things singly and thoroughly at each part of that. And basically that's I just want to say I read the agenda from the administrative committee meeting that was held on January 18th, and there was a compliance timeline, and in that agenda, and also down in one of them, it had referenced the fact that Metler Valley Mutual Water Company had not received a notice of delinquency, and it referenced a statement that says that interest on delinquent assessments shall begin to accrue on the delinquent date. Notices of delinquency for assessment or reports will be sent to delinquent parties subsequent to the delinquent date, which means we should have received a notice after the delinquent date of January 2021. So with all of that said, I just am asking that it would be, our waiver request would be considered again by you. Thank you for your time.
Thank you. Do we have any other public comments for non-agenda items?
Point of this is Calandri. Point of clarification: what are we required to do on this when something is brought up in this part of the agenda?
Nothing, John. It's not on the agenda.
Yeah, good morning, John. Mr. Calandri, this is Matt Knutson. So this is public comment on non-agenda items, so the board can't discuss this item. We can simply take the public comment and go on to the next item.
Thank you.
Okay, is there any other public comments on non-agenda items?
Yes. Can you hear me?
Yes.
Yes, this is Mo's Water. I'm in the neighborhood of Metler Water. I'd like to just ask the board to consider what Debbie from Metler Water is trying to do. It's about 66 people that are involved in this, and it wasn't of their choosing to get in this position. They've agreed to pay the bills, but remember, this is water we're talking about. I mean, it's a necessity. Everybody needs it, and to find someone extra money when they agree to pay for water that's really undesirable. This water is right at the mark of being totally no good. So this is what they're paying for. So I just want to ask the board to consider what she's asking, and that's all I have to say.
Thank you. Is there any other public that would like to comment on non-agenda items? Okay, we will, number 5 is special presentations, which we have none at this time. Next, we will go to number 6, which is our consent agenda, which is payment of bills through February 18th, 2022. Treasurer's report for the month ending January 31st, 2022. Accounts receivable aging summary as of January 31st, 2022, and minutes of January 26th, 2022 regular meeting. Do I have a motion to approve the consent agenda?
Oh, no, this is Dwayne. I'll move to approve the consent calendar.
Do I
I'll
have a
second that.
Thank you. Is there any public comments on that? Okay, we will have a roll call vote, please.
Director Riki,
Yes.
Director Calandri,
Yes.
Director Recca,
Yes.
Director Chisam,
Yes.
and Director McLaren.
Yes, that motion passes. We will go to number 7, which is our advisory committee report. And that will be our advisory committee chair, Chasen.
Hi, this is James Chasen. Can you hear me? Hello, this is James Chasen. Can you hear me?
Yes.
Yeah.
All right, thank you. So the advisory committee met last Wednesday to discuss the action items on the agenda, and all of the decisions are in the memo in front of you. If you have any questions, I'd be happy to answer.
Okay. Do we have any questions at this moment?
None.
Okay.
Thank you.
Thank you. Then we'll go on to our committee reports. The administrative committee.
Yes, good morning. This is Matt Knutson. So the administrative committee of directors, Ariki and Urosic, met last Friday. Things we discussed were the payment of bills. We went through that in detail. That was just approved by the board. We also discussed this settlement payment agreement being proposed on the agenda coming up here with Metler Mutual Valley Water Company. And that's about it, unless the directors have any comments on that.
Any comments, directors? Or questions?
No.
No, nothing for me.
All right. Then we will go on to item number 9, which is consideration and possible action on proposed Metler Valley Mutual Water Company payment settlement agreement. And that will be, our administrator will do that report.
Yes. Good morning again. This is Matt. So on page 29 of your agenda packet is the proposed payment settlement agreement between the Antelope Valley Watermaster and Metler Valley Mutual Water Company. If you recall, last meeting, the board reviewed the template that could be used for agreements such as what's being presented today. So we went through and filled in the blanks, being the Metler Valley Mutual Water Company. And you can see on the first page, page 29 of your packet, there is a payment or installment schedule for paying off the past due late fees. And you can see it's spread out over 4 calendar years with payments being made each quarter within each of those years. So each quarter, they'll be required to pay $738.68. And there is a schedule when each of those quarterly payments are due. So with that, I'd be happy to answer any questions. As I mentioned, this was reviewed by the administrative committee, and the committee and staff are recommending approval of the payment settlement agreement.
Matt, this is Calandri. At this time, I would like to maybe clear the record. I believe Debbie said that it was not a unanimous vote last month. I believe that's incorrect. I was sitting on that meeting, and I remember a 5-0 vote, unless my memory needs to be corrected.
That's not true, John. Director Chisam voted no, and Kathy was a no vote at all.
Oh, then I am totally wrong. I apologize. Thank you.
Well, no. This is Adam. John, you were correctly right. The meeting in November, there was a unanimous vote.
She was referring to
Okay. And then I guess my question is, Adam, then if it was a unanimous vote once, why did we bring it up again?
Our attorney recommended that we re-vote on it during the last meeting.
All right. So now, okay. Okay.
I disagreed with that decision, but he recommended we do, or he said there wouldn't be any harm. Therefore, we took another vote on it.
Okay. Thank you.
Let me refer to the vote that was taken at the last meeting, not the vote that was taken back in October.
And just to clarify, this agenda item is to talk about the payment settlement agreement, not the request to waive late fees.
Yeah, I see that now. Okay.
Yeah.
Thank you.
Is there any other questions?
Nope.
Okay, is there a motion?
This is Derek. I'll make that motion.
Seconded by Adam.
Okay, I have a motion and a second. Is there any public comments on this item? Hearing no public comments, may we do a roll call vote, please?
Director Ricci?
Yes.
Director Calandri?
Yes.
Director Urosic?
Yes.
Director Chisam?
Yes.
And Director McLaren?
Yes, that motion passes. Now we will go on to consideration and possible action on our transfer application. And that will be our staff report engineer will be going over these with us.
Yes, good morning, everyone. This is Phyllis Stannon. We have first of which is a transfer from Rwanda Resourceful to RTS Orchards. And the first three, just FYI, the first three transfers that we're going to go over today are all to RTS Orchards LLC, who is trying to compensate for losing water going forward during the ramp down period. And so the resolution for consideration for the first transfer is on page 33 of your packet, and our analysis begins in our letter on page 35. This transfer is for a one-time transfer of 3,420 acre-feet of water from Gorenda Resourceful to RTS Orchards. Gorenda does have a production right of 629 acre-feet a year, and they haven't used that production right in some time. That has accumulated about 3,484 acre-feet of carryover water, so they do have sufficient amount of carryover water to conduct this transfer. RTS Orchards has a production right of 808 acre-feet a year, and they use that for irrigation on the pistachio irrigation. And you can see that we have provided in the letter on page 35 the past production, just for your information, compared to ramp down amounts for 2016 through 2021. The average there is about 18 acre-feet a year for that time period. RTS Orchards would like to continue doing exactly as they are doing, continuing to farm the same parcels being farmed now with the two wells that they're using on those parcels. And they're trying to secure transfers for the future so that they will have the ability to continue this production when their production right is being ramped down. We have looked at this for material injury and have determined that according to the guidelines in the judgment, the impacts and potential for material injury associated with this transfer would be negligible. So I'll be glad to answer any questions on this one. if anyone has
So-
any, and that's our summary. Yes.
So this is Adam. So this is the last year for the ramp down, correct?
The ramp down goes for 7 years. It began in 2016 and continues through 2022. So that's right. As of 2023, we are back to the judgment's allocation of production rights.
And it ratchets it down, right, over that period.
That's correct.
So the first 2 years, it stays the same, and then it goes down by 20%.
So it goes down. Yes, that's correct.
So for 2022, people can only pump 20% more than what their water rights is, correct? Hello?
Yes. Can you hear me? I'm sorry.
Yes. Did you say yes?
Yes, I did. It's
Okay.
it's a little teeny bit different than exactly 10%, but yes.
Okay. All right. So that slide scale mathematics was taken into consideration in the calcs here.
That's correct. This is right out of the judgment.
All right. Okay. Thank you.
Yeah.
Any other questions on this one? Okay. We'll go on to the next.
Do you want to vote on this first, or
Hold on. I'm sorry. We're doing them all separately. I'm sorry. Okay. Do I have a motion for that? For R2210?
Madam Chair, I have one last question. Where is this pumping going to take place, fellas?
It's on the same parcels that are that they are using now, and it's in the northeastern portion of the West Antelope sub area. The figure that you can look at is figure 1 on page 37 of your packet.
Yeah, I see that. Thank you. Appreciate it. Please, Madam Chair. Thank you.
You're welcome.
This Dwayne Chisam, I'll move on R22-10.
Seconded by Adam.
Okay. A motion and a second. Is there any public comment on R2210? Hearing no public comment, may we have a roll call vote, please?
Director Ricky,
Yes.
Director Calandri,
Yes?
Director Urasa,
Yes.
Director Chisam,
Yes.
and Director McLaren.
Yes, that motion passes. Now we'll go on to R2211.
Okay, great. And so this is the second transfer that RTS Orchards LLC has requested. This one is from Richard Selleck Consolidated Trust. It is a one-time transfer of 65 acre feet of production rights that the Selleck Consolidated Trust has. And so, again, the resolution is on page 46 of your packet, and our analysis starts on page 48 of the packet. Just to be clear, we included that same table in the letter for production and ramp down for RTS Orchards, just so we would be able to keep up with what was happening here. The details of the production right for the Richard Selleck are shown there in that second paragraph of the letter, and just provide the details and the amount of production rights and carryovers that Richard Selleck has, and the transfer again is just for 65 acre feet of the carryover water, so that they have the amount of water needed for the transfer. We have included figures 1 and 2 that shows, again, the RTS Orchards parcels, and the Selleck parcel, which is the transferred water, is shown on figure 1, in the sort of southwestern portion of the central Antelope Valley subarea. Again, we have looked at water levels in the areas of RTS orchards and determined that with respect to the material injury analysis that there's a negligible impact associated with this transfer. So we recommend that the transfer be approved. Any questions on this one?
Luckily, some of this water is going to go for over pumping in 21.
Yes. Yes.
Okay. And possibly in 22, correct?
Yes. That they, as you can see, they're lining up their water supply so that they continue irrigation in the same manner that they have over the last few years.
Right. All right.
Is there any other questions, or may I have a motion on R2211?
I move that we approve resolution R22-11.
Second.
Okay, I have a motion and a second. Is there any public comment on R2211? Hearing none, we will have a roll call vote, please.
Director Ricci,
Yes.
Director Calandri,
Yes.
Director Urasic,
Yes.
Director Chisam,
Yes.
and Director McLaren.
Yes, that motion passes. We will go on to resolution 2212.
Okay, and that resolution is on page 58 of your packet, and our analysis begins on page 60 of the packet. So this is the third of three proposed transfers from a production right holder or carryover water right holder to RTS orchards. And this one is from Stephen Selleck Consolidated Trust. Again, this is 65 acre feet of carryover water from that account moving over to RTS orchards. We have again included the table of production and ramp down for RT orchards so that you can continue to see the proposed transfer plan for this water. At this point, I did want to mention that the advisory committee took a look at these three transfers, noticed that we had three transfers all going to the same party, RTS Orchards. And they had a question regarding the fact that we had three transfers in this one packet. And the question involved cumulative analysis. And so the exact question from the Antelope Valley Watermaster Board Memorandum, which actually is in your packet also on page 24, it's at the bottom of page 24. The question is, did the Watermaster engineer investigate the cumulative material injury for this transfer in combination with the R-Selleck and S-Selleck transfers to RTS? In other words, the committee was concerned how you have three transfers going to the same place. When you look at them individually, perhaps the analysis would be different than if you looked at them all together. And the specific question that they ask is, would the outcome of the material injury analysis be the same after that analysis? And so for this particular transfer, and one of the things that I've tried to highlight as we've gone through these three is that RTS orchards would not be pumping locally more than they have been pumping over the past 6 years or so. And as a result of that, these transfers are sort of moving in the direction of just maintaining local pumping to be the same. So for this particular analysis, a cumulative analysis, I think, would be the same as it would be for the individual analysis here, in that as long as we aren't increasing production locally, then we would not expect material injury to occur from the cumulative transfers or the individual transfers, as the case may be, for these particular transfers. If these transfers were going to increase pumping overall, either individually or cumulatively in this area, then we would need to have taken a more closer look at local water level impacts from the transfer. But in this particular case, the amounts locally are not being increased. I'm sorry?
Shouldn't the analysis be made relative to the ultimate water rights as opposed to what has been being pumped during the ramp down period?
Yes, and they have been pumping their water right. RTS Orchard only has a production right of 808 acre feet, and so as they are being ramped down, the amount of transfers in this particular case, plus their production right, would be needed to keep them sort of maintaining the status quo. Does that make sense?
Kind of, but I get you. I don't know. Yeah, I'm not. If you did the material injury analysis for the larger amount, I'm fine with the 65. The only thing is why this is the same producer selling to RTS orchards. Why didn't we combine the 265s? Is there a reason they were separated?
Only because they come from two separate water rights. As you might see in that second letter, both Stephen Selleck and Richard Selleck are successor trusts, but they have the production rights split evenly among themselves, and so they can't sell each other's rights.
Okay, so they're not the same name. They're just the trust name is the same.
That's exactly right.
Okay. All right.
Okay, is there any other questions for R2212? If not, can I have a motion, please?
So moved.
Again, go ahead, John.
Calandri moved.
Seconded by Adam.
Okay, I have a motion and a second. Is there any public comments on Resolution 2212? Hearing none, may we have a roll call vote, please?
Director Ricci?
Yes.
Director Calandri?
Yes.
Director Urosic?
Yes.
Director Chisam?
Yes.
And Director McLaren?
Yes, that motion passes. We will go on to Resolution 2213.
Right, that resolution is on page 71 of your packet, and this transfer is from Nick and Janet Van Dam to Rosamond Community Services District. It's a permanent transfer of 350 acre feet of production rights from the Van Dams to Rosamond. And this is another condition where a production rights holder is trying to secure additional water rights going forward so that they can maintain their current levels of pumping during the ramp down process. And as a result of that, we went ahead and put the Rosamond CSD production and ramp down amounts in the letter. You can see that on the first page of our letter on page 73. Again, this is from Nick and Janet Van Dams, who have a Exhibit 4 production right of 496 acre feet a year that came from a variety of transfers and property right splits there as well. And the material injury analysis, again, is summarized in the remainder of the letter. Essentially, the Rosamond CSD is not only securing additional transfer water to account for ramp down and compensate for the declining amounts of water available to them during ramp down, but they also are doing a variety of additional water securement processes, and that's shown there on the top of page 74, including their upgraded wastewater treatment plant, which is under a storage agreement that was approved by this board last year. Well, actually in 2020 now. And so in addition to that, we have looked at water levels that are local to the area, and that's indicated on the figures that you see on pages 76 and 77 of your packet. We don't have a significant decline of water levels in this area associated with Rosamond's current production, and therefore we would not expect material injury to occur from Rosamond continuing to pump similar amounts in that area into the future. And so as a result of that, I think that the material injury analysis as defined by the judgment is negligible in this transfer as well, and we would recommend approval. Be glad to answer any questions.
Does anyone have any questions? May I have a motion?
This Dwayne Chisam, I'll move for approval.
Calandri will second.
All right. I have a motion and second for Resolution 2213. Is there any public comment? Hearing none, may I have a roll call vote, please?
Director Ariki,
Yes.
Director Calandri,
Yes.
Director Urasic,
Yes.
Director Chisam,
Yes.
and Director McLaren.
Yes, that motion passes. Now we will go on to item number 11, consideration and possible action on well applications. We will begin with Resolution 2214.
Okay, great. This is Phyllis Stannon again, and for our 2 new production applications that we're going to be reviewing with the board today, I would like to introduce one of our new staff members that's going to be handling this. Ms. Arden Wells is on the line. She's a hydrogeologist with Todd Groundwater. She has a bachelor's in geoscience from the University of Texas and a master's in earth science from Stanford, and has provided a tremendous amount of expertise, especially with water quality, to our firm since joining us several years ago. She's been working recently in the Coachella Valley Water District on their managed aquifer recharge, doing some of the well construction in the area as well. She's assisted with many of our groundwater sustainability plan projects. And so that is excellent expertise that she has developed to bring to our material injury analysis, which is a very similar process to that in this judgment. She's also been involved in installation of injection wells in one of our managed aquifer recharge projects in Monterey. And importantly, I'd like to also point out that she's assisted already on the Antelope Valley Watermaster project for us, including some of the analysis for our 2020 annual report. And she's also been shadowing Kate with respect to the water accounting process, as well as the application review process. So if I can introduce Arden Wells to you now, she will be glad to go through our new production applications. Arden, are you available on the line?
Yes, thank you so much for the introduction, Phyllis. And I'm looking forward to continuing working with this project and kind of learning the ins and outs. So the first new well application that we have is the Glen Bachmas application. It starts on page 87, and the Todd kind of analysis of it begins on page 89 of the packet. So this is for a 1.5 acre foot per year production rights under the non-pumper Willis class for Glen Bachmas, and this will be used for domestic purposes for a single family home. The home will be about 3,900 square feet with a large attached garage that's 1,100 square feet. And there's also going to be an estimated 500 square feet of irrigated landscaping, and that will be drought resistant landscaping. So reviewing this, we decided that because it's only 1.5 acre feet and they've agreed to pay the replacement water assessment, that there will not be material injury for this new production well.
Okay, is there any questions?
No.
All right, can I get a motion, please?
This is Adam. I move that we approve resolution R-22-14.
This is Derek. I'll second.
Okay, I have a motion and a second for R22-14. Is there any public comment on that resolution? Hearing none, may I have a roll call vote, please?
Director Ariki,
Yes.
Director Calandri,
Yes.
Director Urasic,
Yes.
Director Chisam,
Yes.
and Director McLaren.
Yes. That motion passes. We will go on to resolution 22-15, please.
Thank you. So this next new production application is for a well called William Chalman. And this is going to be a domestic well that's shared between two single-family homes on different parcels. And the water use is estimated to be about 5 acre-feet per year, with 2.5 acre-feet per year per parcel. And there's a shared well agreement that is included in the application. So each home.
Yes. That motion passes. We will now go to our administrator's report.
All right, thank you. Good morning again, this is Matt. So the only item I have to report this morning on is kind of go through the proposed timeline and process for going through and selecting a new administration group to take over in the coming months. So, this, like I said, this is what we propose. Feel free to comment on this timeline if you don't feel it's sufficient, but we're planning to have a draft RFP or recruitment document available in coming days. I'd like to have an administrative committee meeting on Friday, March 4th to discuss the draft and get feedback from Directors Urasic and Ariki. And then once we go through that process, distribute the revised draft on March 9th to the advisory committee for their input and feedback at their March 16th advisory committee meeting. And then we'll present that same final draft document to the WATERMASTer board at the regularly scheduled March 23rd WATERMASTer meeting. And if everybody's in agreement at that time, we would release the RFP recruitment document for just over a month between March 24th and April 29th. And we can talk about the process and where we want to advertise and distribute that at the March 23rd board meeting. And then hopefully, if we get some good proposals, we'll review those with both the advisory committee and the WATERMASTer board at the May meeting, and then develop a transition plan to get a new administration team on board for the WATERMASTer. So any initial comments? I know everybody's seen this for the first time, but this is what we're proposing to kind of kickstart the process.
This is Adam. Matt, thank you. This is going to be a full-time position, correct?
I think my recommendation is we just put it out there, outline the scope of work, and then see what kind of proposals we get. I envision that we may get a combination of individuals or firms or maybe other agencies that want to take over this duty for the WATERMASTer. So we'll have to kind of wait and see what kind of proposals we get and feedback.
So the proposal is going to be in the form of we're looking for somebody to provide these services.
Correct.
As we did for the WATERMASTer engineer search.
Yes.
Kind of similar. I see.
Yeah. Very similar. Yeah.
Okay.
So hopefully this provides enough vetting and feedback from the board and the advisory committee and various producers. But we can always revise this timeline as we move along. But we would like to get this process started in the month of March.
All right.
Hey, Matt, this is Derek. So this is, I mean, similar, and I think this is what Adam was asking, is this is similar to the process we did for the engineering council, right?
Correct. Very similar.
Okay, great.
Yeah.
I think it looks great. Thank you for putting it together.
Yeah, you're welcome. Hopefully it goes smooth. So if anybody knows of anybody, get the word out that this is coming.
The way you're structuring it, Matt, is excellent because I think it opens the door for including our watermaster engineers firm if they're interested in providing that service. So I think that's a smart approach.
Yeah, and you'll see in the RFP recruitment document, we leave that open to where we would entertain proposals from, like I said, individuals, firms, or other agencies that want to take on the role similar to what we're doing now.
Like that. Great. Thank you.
Yep. Thank you. And that's all I have to report today.
Thank you for that. Okay, we will go to the Watermaster Engineers Report.
Thank you very much. We have just two quick items today. The first is a letter to the Department of Water Resources. This is something that you've seen very similar in your packet in the past. As you might recall, adjudicated basins in California are required to do reporting to the Department of Water Resources in compliance with the Sustainable Groundwater Management Act, or SGMA. And our reporting is due on April 1st, 2022. The first year that this was required, we worked with the Department of Water Resources and we said, would you like for us to go ahead and upload our previous annual report on April 1st? We will always be a year behind if that's the case. Or would you rather allow us a little extra time because our report is due to the court on August 1st? And then we can provide all of our water use information along with our annual report. And the Department of Water Resources said that they would prefer the latter, that we do wait until August 1st to upload our water use information. But because April 1st is actually in the legislation, they had to have something happen on April 1st for compliance with the act. And so as a result of that, they've set up the system whereby we report April 1st with this letter. And this letter simply explains to the department that we are putting together our data for water use for the previous calendar year, which is what is required for the 2021 annual report, and that it will be finalized on August 1st, and we can upload it at that time. That gives us the opportunity to go into their system and click in their water use data request areas that data are not available. And so this satisfies the compliance requirement in the law, and also gives the Department of Water Resources the opportunity to just wait until August and then have more updated information than they would have had otherwise. So I'll be glad to answer any questions, but this is a letter that you've seen over the last 2 years, and it's essentially the same letter going to the department with respect to SGMA compliance.
We don't need to act on this, do we?
No, you don't. I just wanted you to know that it was happening, and you have your letter there. It's getting ready to be uploaded onto the SGMA portal under your adjudicated basin portion.
Perfect. Thank you.
You bet.
I think we're good with it. We've heard it about 5 times now.
Okay, I'm going to move on then. Thank you. So the last thing that I have is the table that you have requested always be included in your board packet. It is the table on page 142 that shows new production and the unknown small pumpers that have now qualified to be small pumpers under the judgment. And similar to the format that we've used in the past, the top portions of those tables are by year that the applications were approved, and the bottom portion by sub-area to just give you a sense of where things are occurring. The 2022 data that have been added was the result of the January approvals for new production. There were 2 of them totaling 3.5 acre feet a year, and that's shown on new production for year 2022. And for the small pumpers, we added 1 small pumper in January in 2022, and that's where that 3 acre foot a year comes from in that table. So I'll be glad to answer any questions on these tables. Again, these are similar tables that you've seen before.
Mm-hmm. Wow. So the total
new production application is different on the calendar table versus the regional table or sub-area table. Why is that number different?
Where's that?
The final number is right. It's just the 472 is the same number. I don't know why it's 151 and 97.
Yeah, thank you for catching that. I think that's an error. I'm going to check that.
Sorry.
Thank you. No, I'm glad you did. I'll make sure I got that right.
Yes.
Thank you.
And let's just remind us, fellas, the total number for the small pumpers that the court set aside, was it 3,800 acre feet?
I don't remember the total. Does staff remember that total? I mean, that sounds about right.
Can you repeat
it sounds about 30.
please?
The number, the estimated number of small pumpers under the judgment?
Right.
They're known small pumpers. I believe there's about 3,500.
But the acre feet is about 3,800.
Yeah, and I just wanted to explain why the charts are different as well. The top chart is approved new production per year or by year. And there was a temporary production, new production application that was approved for Ron Bannock. And you know what? I really wanted to explain this because I do know it. Yeah.
Is it because 2021 numbers missing? Is that why 2020 was 97 and the balance was in 21?
I believe it was because one application was just temporary, so she showed it in the years, but the sub-area, she showed it as a whole. I'm sorry, I actually had it, and then I should have never opened my mouth. I did understand it for a minute there.
All right. Well, you'll clarify it for the next meeting.
I will, because I'm going to figure it out. Thank you, Derek.
Thank you so much.
Thank you. If there's no other questions, we will go on to the General Counsel's report.
Yes, well, I wanted to update you on where we are on several matters, and we'll have a closed session on 3 matters, so I'll reserve comment on those till we're in closed session. You recall last month we worked to produce 5 enforcement letters, notice letters to 5 various parties. We've gotten written responses from 2 of the parties. One of them, Wagas Land, response is in your packet at page 145. We also, just in the last few days, there's been contact with the staff from Rancho Sierra, which is important to note. 2 of the 5 recipients had not updated their agents for service of process, and we had to reserve them, so their 30-day period to respond will be in March. So we'll have to see whether we get responses from them. And then 1, the Antelope Valley Resource Conservation District, we've gotten, I believe, no response, though staff may have received something. I've received no response from them. The strategy here next is to set for closed session next month what response we want to have to each of these both the letters from Rancho Sierra and Wagas. Presumably will continue to cooperate with them. But from the three parties that we've heard nothing from, we'll discuss in closed session further steps that the board wants to authorize on those two. There's also comment in the report list of the enforcement order with respect to the Tapia parties. I'll report on that in closed session, but the letter to Tapia's council is at page 147 of your packet and was given 30 days. Council was given 30 days to respond to that letter, and that pushes it into the first week of March. So we may still receive substantive response to our letter setting forth how we plan to proceed to collect the additional about $65,000 that's owed by the Tapia parties, who have paid $180,000 so far. In February, there were a couple of court hearings, one dealing with the Zamalza parties that we'll discuss in closed session. We have another hearing in that matter in about a week and a half, and we can discuss where that matter is proceeding in closed session. The other hearing was in February 18th, and it was on the topic of whether Judge Comar will continue to preside over the rest of the Antelope Valley cases, and while he sends to another judge the resolution of the wood class fee application that the wood class got a Court of Appeal decision on. The Court of Appeal basically ruled that Judge Comar had to re-look at the award of attorney's fees in that matter, and the question then became whether Judge Comar would recuse himself from that hearing and from the entire Antelope Valley case based on some allegations of potential conflicts of interest. At the February 18th hearing, it was clear that the wood case would be remanded to the Los Angeles Superior Court for reassignment on a hearing on all the matters related to the wood appeal on attorney's fees. So that proceeding will not be heard by Judge Comar, but by another judge by assignment. But Judge Comar will continue. It was in the agreement of the parties at the February 18th hearing. It still has to be put in a written order, but it's clear that Judge Comar will continue to preside over the remaining actions in the Antelope Valley case, so we won't be losing our judge for purposes of all the matters that we have in terms of the WATERMASTer. So that occurred on February 18th. Both the Zamalza motion, which I'll cover in closed session, and the issue of whether Judge Comar will continue to preside over the rest of the case while another judge handles the wood class appeal with respect to attorney's fees. The last matter of update for the board asked at the last session that we keep track of the Rosamond Community Services eminent domain action with respect to the Calandri interests. And we can confirm that that matter has been resolved, at least in terms of the Rosamond Community Services District, rescinded their resolution of necessity and dismissed the case. So there won't be any further need to update the board on that unless the board has other questions. But the case has been dismissed, and we won't be, there's nothing further to follow, at least in terms of court pleadings with respect to that eminent domain matter. So happy to answer any questions on those 4 matters.
Has there been a court date for hearing the wood class?
No, there hasn't, Director Riki. It has to be first remanded to the Superior Court in Los Angeles. There's supervising judge that handles these kinds of things, and then there'll be notice given about when that will occur. But as far as a date set for hearing on the wood appeal and a judge assigned, there is none as of today.
Okay. All right. And then the clarification. So the eminent domain is not going to happen. Is that what you meant by what you told us?
That case is terminated.
Thank you. I mean, I surmised that much from what you said. I just wanted to be clear. Thanks.
Yes. And that's my report, Madam Chair.
Well, thank you very much. We will go on to number 15, which is board members' requests for future agenda items. Do we have any requests for future agenda items?
We're going to have the item for the administrative engineer, so that's good. We don't need to add it, but we're going to have it there. Other than that, I can think of them from my end.
Okay, if we have no other board members' agenda item, we will go to the closed session conference with legal counsel.
Okay. Do we need to log on and off? I know we ask this question all the time, but sorry.
No, just stay on and we'll move you over, but we do need a motion to go into closed session.
Okay.
May I have a motion for closed session?
I move that we
go.
Second.
Okay, roll call vote, please.
Director Riki?
Yes.
Director Calandri?
Yeah.
Director Urasa?
Yes.
Director Chisam?
Yes.
Director McLaren?
Yes. All right, we are moving over to closed session.